The original Assisted Decision-Making Capacity Act 2015 was signed into law on the 30th of December 2015. This Act applies to everyone and is relevant to all health and social care services. The Act is about supporting decision-making and maximising a person's capacity to make decisions. However, the Act will only be commenced in June 2022, almost 7 years after it was signed into law, because the systems required to implement the legislation were not put in place. I suppose we all know people who have had accidents or have had a stroke or a heart attack and had no plan in place for any decision to be made and had no one appointed to make decisions for them if they were unable to communicate. Most people, if they have someone appointed, will know the person's wishes, what they would have liked to be carried out after they've been struck with some serious illness. But in some cases, families do not want the hassle of having to help take care of their family member. Also, there can be financial reasons why the family would like their member not to be left alive as such. They don't want any of the members' money going to waste as such. Instead, in some cases, the family would prefer to make the decision to end of life. That does not bode well for the member who is incapacitated. Sometimes it falls on friends to advise the family of the person who is incapacitated, which in itself can cause friction and unnecessary bitterness. Another issue is if there are wills being made when the person who is incapacitated is being coerced into signing these, when in actual fact this is not what they want on their will at all. If an incapacitated person would rather be in a certain hospital or a certain nursing home or a community hospital, then this should also be taken into consideration. People who are left in an incapacitated state are extremely vulnerable to the immediate people around them, and at all times must be protected, and their wishes always must be a priority. Over the years, I have heard and seen many elderly people being coerced into making wills, and then, once all is signed over, there is no one left to take care of that person. I have heard of people taking farms and lands off of incapacitated people. I've also heard of families wishing their incapacitated family member was dead, as the cost was too much. Not that they were using any of their own monies, but they didn't want the incapacitated person's money being used up in any medical care, such as nursing homes or community hospitals. The situation today is that if a person loses capacity, for example, incurs an acquired brain injury, the Health Service Executive HSE could apply to have that person made a ward of court. Awarded. Two committees would then be appointed, one to look after the person and the other to look after the person's property, which will often contain a compensation award. Thankfully, under the new Act, it will be possible for a person to specify what decisions they would like made about their person and our property in the event of them losing capacity via an enduring power of attorney and advanced healthcare directive. In the event that a person does not have an EPA or EHD and they lose capacity decisions, support can be put in place depending on the severity of the capacity loss and degree of support needed. A decision-making assistant, co-decision maker or a decision-making representative could be appointed. That person may be next of kin, but not purely by virtue of being a next of kin. It will be done via a court application to be made a decision-making representative, or by signing an agreement with the appointer to be a decision-making assistant or co-decision maker and registering that agreement with the DSS. If the relevant person does not have anyone who could or would step in to one of these roles, the courts can make a decision for the relevant person or choose a decision-making representative from nominees nominated by the Director of the DSS. Thank you.